Okay, I'm about to read Kentucky versus King. Justice Alito delivered the opinion of the court in 2011. An undercover officer watching a controlled buy of crack cocaine radioed nearby uniformed officers to apprehend the subject, who was moving quickly towards the breezeway of a nearby apartment building. As officers entered the breezeway, they heard the door shut and detected a strong odor of burnt marijuana. The officers did not know which of the two apartments at the end of the breezeway the suspect had entered. But because they smelled marijuana smoke emanating from the apartment on the left, they knocked on the door and announced their presence. They immediately could hear people moving inside, as well as sounds as though things were being moved inside the apartment, which one officer later testified led the officers to believe that drug-related evidence was about to be destroyed. The officers then entered the apartment occupied by King and others, and the subsequent search found drugs, cash, and drug paraphernalia. The original suspect was later found in the apartment to the right. King was convicted on drug charges after the court denied his motion to suppress, ruling the search was one, based on a probable cause, and two, probably made without a search warrant, given an important variety of exigent circumstances. As the Supreme Court has put it, the need to prevent the imminent destruction of evidence. The Kentucky Supreme Court reversed, concluding police may not rely on exigent circumstances if it was reasonably foreseeable that investigative tactics employed by the police would create the exigent circumstances. Oh, that's interesting. Where'd that come from? The Kentucky Supreme Court reversed. Okay. Oh, that came from this case. So that's the Supreme Court. But the trial court convicted them. And over the years, lower courts have developed an exception to the exigent circumstance rule, so-called the police created exigency doctrine. Under this doctrine, police may not rely on the need to prevent destruction of evidence when that exigency was created or manufactured by the conduct of the police. Another type of exigency was addressed in Brigham City versus Stewart in 2006, where unanimous court declared one exigency obviated the requirement of a warrant is the need to assist persons who are seriously injured or threatened by such injury. Accordingly, law enforcement officers may enter a home without a warrant to render emergency assistance to an injured occupant or to protect an occupant from imminent injury. The officer's entry in the instant case was lawful, for they had seen through a screen door and window that a juvenile being held back by several adults had broken loose and struck one of them sufficiently hard that the victim was spitting blood, and thus had an objectively reasonable basis for believing both that the injured adult may need help and that the violence in the kitchen was just beginning. So Wren is also cited in the footnotes, and so is Michigan versus Fisher. Wren, we've read, an action is reasonable under the Fourth Amendment, regardless of the individual officer's state of mind, as long as the circumstances viewed objectively justify the action. In Michigan versus Fisher, 2009, the court rejected Fisher's argument that the officers here could not have been motivated by a perceived need to provide medical assistance since they never summoned emergency medical personnel. Failure to summon them conclusively established the officer did not effectively believe that Fisher or someone else was seriously injured. The test, as we have said, is not what the officer believed, but whether there was objectively reasonable basis for believing the medical assistance was needed or the persons were in danger in that case. So that was the case note. So back to the present case. The lower courts have held that the police created exigency doctrine requires more than simple causation, but the lower courts have not agreed on the test to be applied. Some lower courts have adopted a rule that is similar to the one that we recognize today, but others, including the Kentucky Supreme Court, have imposed additional requirements that are unsound and that we now reject. Bad faith. Some courts, including the Kentucky Supreme Court, ask whether law enforcement officers deliberately created the exigent circumstances with the bad faith intent to avoid the warrant requirement. Okay, so there's a bad faith test. The approach is fundamentally inconsistent with our Fourth Amendment jurisprudence. Our cases have repeatedly rejected a subjective approach, asking only whether the circumstances viewed objectively justify the action. Indeed, we have never held outside limited contexts such as an inventory search or administrative inspection that an officer's motive invalidates objectively justifiable behavior in the Fourth Amendment. Crim versus United States, page 176 of this book. The reasons for looking to objective factors rather than subjective intent are clear. Legal tests based on reasonableness are generally objective, and this court has long taken the view that even-handed law enforcement is best achieved by the application of objective standards of conduct rather than standards that depend upon the subjective state of mind of the officer. Reasonable foreseeability. Some courts, again, including the Kentucky Supreme Court, hold that police may not rely on an exigency if it was reasonably foreseeable that the investigative tactics employed by the police would create the exigent circumstances. Courts applying this test have invalidated warrantless home searches on the ground that it was reasonably foreseeable that police officers, by knocking on the door and announcing their presence, would lead a drug suspect to destroy evidence. Contrary to this reasoning, however, we have rejected the notion that police may seize evidence without warrant only when they come across the evidence by happenstance. In Horton versus California of 1990, we held that police may seize evidence in plain view, even though the officers may be interested in an item of evidence and fully expect to find it in the course of the search. Adoption of a reasonably foreseeable test could also introduce an unacceptable degree of unpredictability. For example, whether law enforcement officers knock on the door of premises occupied by a person who may be involved in the drug trade, there is some possibility that the occupants may possess drugs and may seek to destroy them. Under a reasonable foreseeability test, it would be necessary to quantify the degree of predictability that must be reached before the police created exigency doctrine comes into play. A simple example illustrates the difficulties that such approach would produce. Suppose that the officers in the present case did not smell marijuana smoke and thus knew only that there was a 50% chance that the fleeting subject had entered the apartment on the left rather than the apartment on the right. Under those circumstances, would it have been reasonably foreseeable that the occupants of the apartment on the left would seek to destroy evidence upon learning that the police were at the door? Or suppose that the officers knew only that the suspect had disappeared into one of the apartments on the floor with 3, 5, 10, or even 20 units. If the police chose a door at random and knocked for the purpose of asking the occupants if they knew a person who fit the description of the suspects, would have been reasonably foreseeable that the occupants would seek to destroy evidence. We have noted that the calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments in circumstances that are tense, uncertain, and rapidly evolving. A reasonable foreseeability test would create unacceptable and unwarranted difficulties for law enforcement officers who must make quick decisions in the field, as well as for judges who would be required to determine after the fact whether the destruction of evidence in response to a knock on the door was reasonably foreseeable based on what the officers knew at the time. Probable cause and the time to secure a warrant. So this has like another little, it's in italics, like it's got like a paragraph header. So bad faith was the first paragraph header I saw. Then there was reasonable foreseeability was the second. And now this kind of third subsection, I guess, is probable cause and time to serve warrant. Let's see if there's a fourth. There is. There's a standard or good faith tactics, investigative tactics, and okay. So this will be another page and a half before I get to the dissenting opinion, which has an extremely long case note on Vail versus Louisiana, and Segura versus United States, Illinois versus MacArthur. All right, so back to probable cause and time to secure a warrant. Subpart 3. Some courts in applying the police-created exigency doctrine fault law enforcement officers if, after acquiring evidence that is sufficient to establish probable cause to search particular premises, the officers do not seek a warrant, but instead knock on the door and seek either to speak with the occupant to obtain consent to search. This approach unjustifiably interferes with legitimate law enforcement strategies. There are many entirely proper reasons why police may not want to seek a search warrant as soon as the bare minimum of evidence needed to establish probable cause is acquired. Without attempting to provide a comprehensive list of these reasons, we note a few. First, the police may wish to speak with the occupants of the dwelling before deciding whether it is worthwhile to seek authorization for a search. They may think that a short and simple conversation may obviate the need to apply for and execute a warrant. Second, the police may want to ask an occupant of the premises for consent to search because doing so is simpler, faster, and less burdensome than applying for a warrant. Consensual search also may result in considerably less inconvenience but embarrassment to the occupants at a search conducted pursuant to a warrant. Third, law enforcement officers may wish to obtain more evidence before submitting what might otherwise be considered a marginal warrant application. Fourth, prosecutors may wish to wait until they acquire evidence that can justify a search that is broader in scope than the search that a judicial officer is likely to authorize based on the evidence then available. And finally, in many cases, law enforcement may not want to execute a search that will disclose the existence of an investigation because doing so may interfere with the acquisition of additional evidence against those already under suspicion or evidence about additional but as yet unknown participants in a criminal scheme. As we have said that law enforcement officers are under no constitutional duty to call a halt to criminal investigations the moment they have the minimum evidence to establish probable cause. Halting the police for failing to apply for a search warrant at the earliest possible time after obtaining probable cause imposes a duty that is nowhere to be found in the Constitution. So fourth subpart. Sounds like these are just different minority approaches. So standard or good investigative tactics. Finally, some lower court cases suggest that law enforcement officers may be found to have created or manufactured an exigency in the court if the court concludes that the course of their investigation was contrary to standard or good law enforcement practices or to the policies and practices of their jurisdictions. This approach fails to provide clear guidance for law enforcement officers and authorizes courts to make judgments on matters that are the province of those who are responsible federal and state law enforcement agencies. Respondent argues for a rule that differs from the discussed above, but his rule is also flawed. Respondent contends that the law enforcement officers impermissibly create an exigency when they engage in conduct that would cause a reasonable person to believe that entry is imminent and inevitable. In respondent's view, relevant factors include officers' tone of voice in announcing their presence and the forcefulness of their knocks, but the ability of law enforcement officers to respond to an exigency cannot turn on such subtleties. If respondent's tests were adopted, it would be extremely difficult for police officers to know how loudly they may announce their presence and how forcefully they may knock at the door without running afoul of the police-created exigency rule. And in most cases, it would be nearly impossible for a court to determine whether that threshold has been passed. The Fourth Amendment does not require the nebulous and impractical test that respondent proposes. For the reasons, we conclude that the exigent circumstances rule applies when the police do not gain entry to premises by means of an actual or threatened violation of the Fourth Amendment. This holding provides ample protection for the privacy rights that the amendment protects. When law enforcement officers who are not armed with the warrant knock on a door, they do no more than any private citizen might do. And whether the person who knocks on the door and requests the opportunity to speak is a police officer or a private citizen, the occupant has no obligation to open the door or to speak. When the police knock on the door, occupants choose not to respond or to speak. The investigation will have reached a conspicuously low point, and the occupants will have kind of warning that even the most elaborate security system cannot provide. And even if an occupant chooses to open the door and speak with the officers, the occupant need not allow the officers to enter the premises and may refuse to answer any questions at any time. Occupants who choose not to stand on their constitutional rights but instead elect to attempt to destroy evidence have only themselves to blame for the warrantless exigent circumstances such they may ensue. We need not decide whether exigent circumstances exist in this case. The Kentucky Supreme Court assumed for the purpose of argument that exigent circumstances existed, and it is held that the police had impermissibly manufactured the exigency. We too assume for purposes of argument that an exigency existed. Any question about whether an exigency actually existed is better addressed by the Kentucky Supreme Court on remand. In this case, we seek no evidence that the officers either violated the Fourth Amendment or threatened to do so prior to the point when they entered the apartment. Officer Cobb testified without contradiction that the officers banged on the door as loud as they could and announced either police, 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 or this is the police. His conduct was entirely consistent with the Fourth Amendment, and we are aware of no other evidence that might show that the officers either violated the Fourth Amendment or threatened to do so. For example, by announcing that they would break down the door if the occupants did not open the door voluntarily. Consider Vail versus Louisiana. Okay, like I said, the dissenting opinion really isn't that long, so let's go through with it. It's Ginsburg, of course. The court today arms the police of the way routinely to dishonor the Fourth Amendment's warrant requirement in drug cases in lieu of presenting their evidence to a neutral magistrate. Police officers may now knock, listen, and break the door down, never mind that they had ample time to obtain a warrant. I dissent from the court's reduction of the Fourth Amendment's force. Under the appropriately reined-in emergency or exigent circumstances exception, the result in this case should not be in doubt. The target of the investigation's entry into the building and the smell of marijuana seeping under the apartment door into the hallway. The Kentucky Supreme Court rightly determined gave the police probable cause sufficient to obtain a warrant to search the apartment. As that court observed, nothing made it impracticable for the police to post officers on the premises while proceeding to obtain a warrant authorizing their entry. Before this court, Kentucky does not urge otherwise. And that's that. But the footnotes, Vail versus Louisiana, where police arrested Vail in front of his house after observing him make a drug sale. So they saw him. That was a probable cause, and made a cursory inspection of the house. So, pursuant to the arrest, to see if anyone else was present when his mother and brother entered the premises, prompting the police to conduct warrantless search of the premises, uncovering narcotics, and holding that search to be unconstitutional. The majority asserted that officers were not responding to an emergency, as the goods ultimately seized were not in the process of destruction or about to be removed from the jurisdiction. The two dissenters claim that the court's earlier cases indicated that exigent circumstances exist when evidence or contraband was threatened with removal or destruction, which was so on the facts of the instant case. While Justice Ginsburg is apparently, this is about her dissent, but another similar but not identical situation is Seizure versus United States, 84. The police, upon confirming that they had observed a drug sale by Colon and Segura, went to their apartment building, arrested Segura in the lobby, and then arrested Colon when she answered a knock at the door in the apartment. Police then made a warrantless entry into the apartment and remained there until the search warrant was issued. Interesting. Some 19 hours later, the court held that where the officers having probable cause enter the premises, the probable cause arrest the occupants who have legitimate possessory interest in the contents and take them into custody, and for no more than the period here involved, secure the premises from within to preserve the status quo, while others in good faith are in the process of obtaining a warrant. They do not violate the Fourth Amendment. That holding was explicated in an opinion by two justices. I'm going to keep on going. There were four dissenters. Now, Illinois versus MacArthur of 2001, two police officers stood by outside to keep the peace while the defendant's wife removed her effects from the family residence, a trailer. Upon exiting, she told the officers her husband had hidden marijuana under the couch. So the officers sought the permission to search the premises. When he refused, one officer left to obtain a search warrant while another remained on the porch with the defendant, who was told he could not re-enter unless he was accompanied by the officer. A warrant was obtained and executed 2 hours later. But in the interim, defendant entered the trailer 2 or 3 times, and on each occasion, the officer stood just inside the door to observe his actions. By the process of balancing the privacy-related and the law enforcement-related concerns, the court concluded that the restriction at issue was reasonable and hence lawful in light of the enumerated circumstances. So that was okay. They had probable cause, good reason to fear that unless restrained, there would be destruction, reasonable efforts to reconcile their law enforcement needs with demands of personal privacy. As for the defendant's reliance upon Welsh versus Wisconsin, 1984, holding the police could not enter a home without a warrant in order to prevent the loss of evidence, namely a defendant's blood alcohol level of the non-jailable traffic offense of driving while intoxicated. The majority distinguished this case because it was punishable by jail, and restriction at issue here is less serious. Souter concurring in MacArthur, I'm going to just stop there.